Okay, I see we still have people streaming in, but we can take it away. Hi, Professor Kimuto, how are you? And hello to everyone else. I see Fanny's in the comment section, but I'll just start by giving an overview of the Research to Commercialization program. This program is funded by the UK government through the Research and Innovation Systems for Africa Fund. And Victoria Ventures, in collaboration with the Kenya National Innovation Agency, came up with this project called the Research to Commercialization Project. The essence of the project in itself is just as it sounds, research to commercialization. What motivates the whole program is that there are so many research papers, so many researchers in our institutions who are doing very good research that has the potential to impact the lives of people. So we thought that it would be a noble thing to just reach out to these researchers and tell them that we can go beyond publishing and putting this research on the shelves, but we can move forward and commercialize these innovations, take them to market so that they can be of impact to people. So another thing that we tend to do with this program is that we want to support the establishment of startups from these institutions. So not only the university taking these publications, turning them into products that can be commercialized, but then also starting and developing and establishing startups that can employ other people and can move these innovations to people. So the program in itself comes in two phases and two pillars. One is the accelerator program. So the accelerator program is where we have selected researchers from institutions all over the country. We take them through training, we take them through mentorship, and assist them to think through their funding and commercialization strategy so that they are able to actually take these products to market. Then the other wing of the R2C program is the institutional support, because we realize that these researchers not only function, they're not functioning single-handedly, they're under institutions. So one of the key things, especially in this phase of the program, is that we work hand in hand with the institutions to help them rethink some of the policies that they have so that they can be able to, one, incentivize the researchers in the institutions and to just support them in their journey. So this institutional support comes with training of the trainers of trainers, who are some of the participants that we have online. So we train them and then we assist them. We give them the technical assistance as they cascade these trainings to their institutions. Then the other thing is that just so that the institutions have the institutional heads. So the other thing that the R2C program does is that we reach out to the leaders of this institution, help them to understand what the R2C program can do for the institution in terms of sustainability through training. And then with this plus reviewing of the policies, we are able to continue supporting the innovators and the institutions together. And just as I had mentioned, that the accelerator program, the objective of this program is just to strengthen the researchers' capacity. And then on the other side, for the institutional support, is just to strengthen institutional capacity for technology transfer. Then this far, we have been able to engage more than 30 innovators, both in Kenya and in Ethiopia as well. We've had 11 training weeks this far. We have 312 hours of training. We've engaged, I think by now it's more than 50 trainers of trainers from more than 30 institutions. Then we have also been supporting now with the funding and commercialization aspect of it. We've been assisting our innovators to get funding opportunities, and this far we've had our innovators raise more than 48 million Kenya shillings. Then the other thing is that we have these forums, just like this webinar, for knowledge exchange, where we can bring all the participants of the program and members of the ecosystem just together so that we can share knowledge on how we can move forward in relation to research to commercialization. So again, just to welcome you, the essence of this session is just to learn from each other, learn from the experts in the program. So use this opportunity to just channel your questions and just to answer some of the things that you've not been able to understand in relation to research to commercialization. So welcome again, and we look forward to interacting with you. And I think at this point, I'll just hand it back to Sonia. Sonia, who's the moderator. Karibu, Sonia.
Thank you, Phyllis. And thank you for that update. Good morning, everybody. And thank you very much for joining us today to listen in and get more information about intellectual property and how it does put money in our pockets and earn us revenue as innovators. We have two very busy people, very insightful people who will talk us through this idea and have unique perspectives around intellectual property. One is from the Kenya Institute. I'll let him introduce himself. He's from KIPI. And the other is a researcher, innovator from Egerton University and has been a participant in the R2C program. So to begin with, by way of introduction, I'll invite you, Mr. Zirolewa, to introduce yourself and your role. And in so doing, also tell us what is IP and why is it important for innovators? Zero? All right, let me see what he says. Phyllis Lian, it says the system has logged him out. Are you able to assist? And as that happens, I'll welcome Professor.
Is it fine now from my side?
Yes. Yes. So good morning and welcome. The question to you is to introduce yourself and your role at KIPI and also answer the question, what is IP? Why is it important for an innovator?
Thank you very much, Sonia. I hope I'm audible enough.
Yes.
And sorry for the inconveniences. I was trying to find a suitable place where has good lighting. But my name is Sami Zirolewa, and I'm a senior patent examiner in the area of pharmaceuticals. My expectation here is to basically interact with the participants to understand the roles that we do, and also to understand the role of IP and how it can benefit any inventor there and any entrepreneur who is seeking to benefit from their creations. So in a nutshell, intellectual property are basically creations of the mind, and these are output that originate from research. So if you are faced with a problem in society, you do your research and ensure that you are solving the technical problem or the problem that is facing in society. So generally, we have different types of IPRs. We have the copyright side, and we have the inventions, which includes patents, utility models. So the benefit of IPR to an innovator is that it provides them with a leverage and protects the ideas or the inventions from being misused by the public without them actually benefiting. So basically here is you get protection for a period of time to ensure that you can be able to recoup the expenses that you have been investing in that, and in exchange that you can create economic value as well as solving societal problems.
And when you talk about protection for a period of time, is it a standard period of time, a year, 2 years, 15 years, if one registers their IP, say with KIPI?
There are different types of IPRs that are, or IP regimes that are applicable to KIPI. We have patents, which basically covers inventions, and these are products and processes of manufacture. As long as they meet the criteria, they are usually protected for a period of 20 years, upon and are subject to payment of annual maintenance fees. When I say subject to annual payment of annual maintenance fees, that If you fail to maintain your application or your patent, it falls into the public domain, and anyone else can basically use that invention without any form of infringement or without them being taken to court. Because failure to pay annual maintenance fee, we will assume that you have relinquished your rights. Then we have a lesser version of a patent, which we call a utility model, which is usually basically protected for a period of 10 years. And these are basically minor improvements of products and processes in the market that probably are only new but not necessarily inventive. Then we also have some other IPRs which are beneficial to entrepreneurs and people who are looking to commercialize their products. If you have an invention or have a product that you want to be to the market, and this particular product may require to be packaged in a certain manner, or you have an article or a product that has some sort of appearance that is unique, a shape and configuration that is unique, that influences the market, then you protect this one as what we call an industrial design, which basically protects the aesthetic features of that particular article. And this one goes for a period of 15 years. Basically 2 terms, each term is 5 years, renewable twice. And also that one is subject to payment of maintenance fees.
All right. So I've certainly learned something new. We now refer to it as IPR and not just IP because the registration part is the more important one. And this is the work. Okay, we lose you a bit there.
Intellectual property.
We lost you a bit there. Please repeat that.
Sorry. When you say IP, you are generally talking about intellectual property, which covers everything. But if you talk about IPRs, these are the rights themselves, not generally IP.
All right. I'd like to introduce our second panelist today, Professor Paul Kimurto, and invite him to speak, telling us about his innovation and also his IPR journey, which is different from KIPI. Professor Kimurto, karibu, and thank you for joining us so early. He's in a different time zone.
Thank you, Sonia, and good morning, everybody. My names are Professor Paul Kimurto, as she has rightly put it. I work at Egerton University as a lecturer there in the Faculty of Agriculture and the Department of Crop Science. And I'm also in charge of the Agroscience Park, which is an innovation hub that we normally use to commercialize our products. I'm also a beneficiary of R2C cohort 1 when Kenya put up the interest to train and to also support innovators in the country to try and learn how to commercialize their products. I applied and joined the Victoria Ventures, so we benefited quite a lot on how to convert our research to commercialization. So we are in phase 2 now, where we are trying to see how we can take our product to the market. I come from the crop science department or section where we develop new varieties of crops, new varieties of plant products by pesticides, new products that are used in agriculture mainly. So my innovation has been on development of new groundnut variety, which has got diverse uses. So it's a peanut product. It's an innovation that came from breeding, and we patent our products, not with KIPI, because the plant products are protected by KEPHIS. It is a national regulator that protects plant products around agricultural sector. And therefore, we started this project almost 7 years ago, where we looked at what does the market require for peanut sector. So we assembled the materials that we needed, which is normally called parental materials. And then it looked at what does the market want. So the market for peanut wants roasted peanut, it wants peanut butter, peanut oil, and of course we know the 5 products goes to the animal feed, the peanut cake or groundnut cake. So we developed the product, and when we completed and identified what we thought it was good, you normally take it to CAFES for registration. So you have to apply for registration the way Ciro has explained, that you need to apply your product for patenting so that you can obtain the intellectual property rights. So we did that for a period of, it takes 3 years, and you must actually do what we call descriptor. You must describe what is it unique, what is different, what is the benefit to the community? Why do you need rights? Why do you want to exploit it without being exploited by other people? So we have what we call a descriptor, which actually called DUS, distinctiveness, uniformity, and stability. And this is always, you do that after you have done sufficient research yourself because it's very expensive. If you want to register one product, it could be now, ours was a plant product, or it could be a bio product for fertilizer. It could be a microorganism, like when we have even Avlasif, Kefi in Calro, or such products that come from the agricultural sector. You pay $600 per product, per year, per season. So it is quite, yes, you pay KEFIs. And competitively, it will be tested independently by KEFIs without you. You will only be called to go and check how your product is performing with all the commercial products in the market and that have been released by other innovators. And the product will be analyzed, and then after 3 years, the minister is informed for gazettement if your product is actually among the best. So the Minister of Agriculture is the one that releases, not the KEFIS. The KEFIS is a technical arm, but it is the Minister of Agriculture that sits down, listens to your innovation. You are now called to go and defend your innovation, and you are given an opportunity to give more information through what we call what is new, what is any special attributes in the product. And once the product is seen to be having everything else that is not in the market, apart from the yield, it could be oil, it could be oleic acid, it could be any of the unique products that is in your innovation, then the minister will announce a new product that has been tested by KEFIS, and you now pay the second phase if you want to protect it. That is, so there is the money for testing and the money for patenting now. So you apply for plant breeders' rights. So IPPR, intellectual plant breeders' rights. And you are allowed to now exploit your product. So it takes time. And in most cases, and the reason why there are no products from universities, there are no products from innovation. We do multitudes of research across the country in all the universities, but the products that are coming out, going to the industry for commercialization are very few because the process is fairly challenging. Yes, thanks.
Thank you for that journey of registering your product innovation, and to hear that there's 2 phases, to hear that there's a fee per product, per year, per season. Ciro, I see you want to add on to that journey before I go on to the next point of discussion. Yes.
Yes, and I usually do this so often. Sorry for that. We misuse the word patents. or patenting. And this is something that I want to explain to Prof and the participants. Patents only applies to patents, but not other IPR, to patents, and not other IPRs. You can only register trademarks, you register utility model, you register plant variety rights or a plant breeder's rights. But when you say patenting, patenting is only when you are protecting an invention or a product of manufacture that can be manufactured in an industry. That is one way you can use the word patenting. You can't use
Zero,
the word
are you saying
patenting.
that we seem to be using patent and IPR synonymously?
We seem to use patent. We seem to use the word patenting when we mean protection.
When we mean, okay. So that should be something we need to unlearn.
Yes, because you can, the word patenting is only applying to the process of acquiring patent rights.
And it is a very specific IPR. Prof,
it is a very specific IPR. You can't register a plant variety and you say you are patenting. No, you are protecting a plant variety. You are registering a utility model.
I see. Prof, do Prof still understand when they get to a certain point?
I think I agree with him.
Okay.
He's the expert. He's the expert, so I won't object it. But it is we get the same rights.
It's
correct.
It's protection.
Yeah, we get the same rights. So we can say plant breeders' rights, intellectual property rights.
Yes.
So at least at the end of the day,
you protect your variety.
You protect our variety. We protect our fertilizer. We protect our new product. So
yes. Okay.
So it's actually I agree. I think he's the expert. Yeah, thanks.
So that's something out of here. And to those who are joining us, please feel free to write your comments or your questions. We'll get to you in a little bit. But I want to ask around pitfalls on IP registration, which I think, Zero, you started us on, in terms of clarifying what protection is. As an examiner of applications submitted to KIPI, what are some of the pitfalls that you see innovators, researchers, entrepreneurs fall into when they are applying for IPR and the different versions of them?
One of the basic things that majority of these researchers or entrepreneurs miss is whatever I was just trying to correct, Prof. Someone has an invention, but they don't really understand what kind of IPR falls in. To the extent that they lack the knowledge to understand the various types of intellectual property protection that they can explore for them to be able to gain much economic sense in their invention. So, for example, someone has come up with a formulation, let's say a baby formulation, but maybe this person doesn't really understand whether they will go for a patent or a utility model, or for a trademark for that matter or something. They don't understand or they don't have the knowledge to evaluate which kind of IPR regime to follow. That is one. Then as an examiner, the other problem is that people have a problem putting the right content for protection. Prof explained that when you are seeking plant variety rights, there is a descriptor, and that allows the person who evaluates your variety to be able to distinguish and also to see, is this variety meets the US criteria over time and the stability. So the person needs to be able to read the descriptor and all that one, and it has a specific form. So for us also here, when it comes to patenting or registering utility model, you need to be able to describe your invention in a certain manner and in a certain format. And it forms a certain language which needs to be made so that it can be registerable. And this is one area whereby I think Kenya has done a lot in terms of educating people. Also, other organizations, we have done a lot as our mandate to disseminate information in terms of teaching people on how to come up with this particular document, because it is that document that goes ahead to ensure that your invention is protected. But from my experience, majority of these inventions, they do not fail because they don't have the substance. They fail because they don't meet simple formality and drafting issues.
And these drafting issues, so if I get the type of IPR wrong, say I apply for a utility model instead of a trademark, what does that mean? You reject my application and I have to start again and pay again? Is that what happens?
When it comes to industrial property rights, now let's move away from intellectual property as a broader IP perspective. Mm-hmm. When we talk about industrial property rights or IP in general, we have what we call marketing tools and we have the inventions themselves. The marketing tools here are the trademarks, because the trademarks is the one that distinguishes your company and your product in the market. Mm-hmm. But when you come to us here, you protect a technology. For example, if you protect a baby formulation, the baby formulation does not have a name. It's just simple, a NutriPorridge. But when you want to now take the NutriPorridge to the market, you will have to have a name. You call it, assuming you call it Uji Power. Mm-hmm. I'm not marketing any other product here, but I'm just using for purpose of example. So the formulation, the baby porridge formulation, if it qualifies, it will be registered as a utility model. There is no way like you register, you will mistake a patent or a utility model with a trademark. The only mistake that usually comes here is protecting a utility model when you meant a trademark, a patent, or not protecting a utility model by describing it in other forms, like you go to copyrights in forms of a corporate publication. Understand? So you are interested in making a publication and a copyright, but you are forgetting that the publication carries the technology that ought to be patented or registered as a utility model.
All right.
And this happens mostly in universities, whereby they're more interested in publishing the technology in a journal, but they fail to understand that the journal carries a lot of technology that needs to be patented or registered as a utility model.
So even as I publish in a journal, if I'm in a university setting, it's important that I find ways to protect before I publish or as I publish. Is that what you're
actually the sequence is you conceptualize, you research, you protect, and then you commercialize. When you publish before protection, it means you have already disclosed the public. And if you publish a publication today, then you have to make sure that you come to keep it within 12 months as mandated by the Act, because there's a grace period to do that. However, we do encourage people that before publication, make a formal application to KIPI or any other IP office before you publish. Because there's something what we call a novelty. We usually check novelty from the filing date. So to prevent your application from losing novelty, you basically have to file with us before publication, because your own publication will be used as prior art against your patent application.
When we spoke, Professor Kimurto, when you joined the program, there was this really serious conversation about, have you registered your IPR? Did you, in the journey that you had over the last many years, did you have to review your process? Zero has talked about research, protect, commercialize. Did you follow that? Were there any challenges you faced as you were heading towards protection and then going to market?
Yes, that is a good question. You must make a decision at the beginning whether you are research, because most of these products come from research. Most of them come from research, and therefore, in the process of having your hypothesis, whether in the research you want to do, are you going to have anything better than what is existing? So once you have already have the right hypothesis, the right questions, and you complete the process of research, you identify the product. One of the first difficult challenge is what he has already clearly put it. What is it that you want to protect? What is it that you want to register? So one of the biggest challenges that occur is knowledge. Whether if your institution doesn't have an IPR policy, if the institution is not motivated to educate and to also inform its scientists or innovators, but you can't be an innovator if you have no knowledge. So in most cases, institutions that have got an IPR and some experience of applying for patenting, protecting their products from research, will always inform. They'll always search around, even as you talk about your products, your research, as you talk about your product, your research in conferences or in meetings, there is a possibility that if the IPR in the institution is existing, you may be informed about possibility of your product having done, if you get things that are unique from the research, then it is at that point that you may be requested to apply for, or you as an innovator, you can be motivated to look at what is it that is in the market? What is it that is in keeping?
Prof.
How different is my product? Yes.
Allow me to manage time and ask you, in your
journey, okay.
In your journey, which challenges did you face?
The biggest challenge is funding.
For this registration or funding
for the registration. Yes. The biggest challenge is funding for the registration. KIPI require money. He has put it. You can't take a product for registration or for patenting or for protection without resources. I don't know how much Lewa will tell us the cost. In KEFIS, it is $600. It's not small money if you are not supported. The second one is actually the description of your innovation. The forms that are in the websites for KIPI, for KEFIS, and all these organizations are not just easy because it takes a lot of time to fill in because they also want to ensure that it's something new, and by the time they put in their website, it doesn't mean that it is something that it should be new. So the application process is difficult. The next one is the duration. It takes time before you get feedback. I don't know, Lewa will tell you, you apply, you pay, and maybe you'll get negative feedback. It doesn't mean that when you apply for registration, it will be registered as new product. It may not be the best. They go and validate. I don't know how they test. For KEFIS, they will test in 6 sites if it's a product. 6 sites, 3 years. So Lewa should tell us what do they do for this long period of evaluating your innovation. After that, then the challenges around even for you may be told to bring other new innovations and other new traits, new characteristics. For me, we were told to bring new analysis of oil content, vitamin E. There are some other characteristics that the registration process may require, which require maybe 2 years later, you are told, okay, we think your product can be registered. Can you provide us with this additional information? And in most cases, it is either a redrawing or a description, it will require money.
Well,
So
and how did you raise your money, Prof?
we raised our money through research, mainly, and also
Research grants?
research grants.
Okay.
Research grants, mainly.
I'm going to invite, before we close, Zero to explain to us where this time goes. But for now, I want to ask you, Prof, that we talk about your product. How have you chosen to commercialize? What are your options for this innovation that you registered? What does it look like now as a commercial product? And is it making you money?
Yes, it is. It's making a lot of sense. It's one, of course, we've been talking about it, that we have a product, that we registered it. It attracted the attention of Kenya. So Story of Angels has given us some resources. And we want to market it as seed. So we are marketing. Our first line of customers are the farmers. We are also talking to seed companies. We are talking to NGOs. We are talking to the ministry. We are talking to any consumer of good groundnut variety based on the huge importation that we are bringing also from Malawi and most of these other areas. So we are creating market around seed systems in institutions and farmers who want to get a new and a different groundnut variety. And we are also talking to processors, because the processors are the pool. So we talked to Green Forest a year ago. We talked to the Insta Foods. We talked to it. So we have some traction around demand from the pool side, so that we commercialize the seed. So that is what we are doing now.
And in the commercialization, I know I have heard there are different pathways. As being a non-expert, whether you license your technology, what path have you followed in terms of the commercialization path? Are you producer and marketer, and you take the whole process with you? You maintain it with you, or are you licensing it for others to produce? What path have you taken?
We are eventually we are going to license out. But for now, we are still doing it because we also want to build a startup. You know, this is a product that we developed from the institution of employment. So we want to have a startup that eventually we will register it as a company that will eventually look at scale in terms of doing a small percentage of the market, and then give license to other people to produce.
Okay.
Yeah.
Zero, back to you in terms of you're the examiner, you approve an application which is based on the technology and not so much what goes to market. What are some of the technologies that are protected that we see in our Kenyan market that are commercialized?
Thank you so much for that question. As an example,
please start again. We are losing you. Zero. Oh, let me reach out to him. He might not be aware. Zero.
So I'm saying, yes, I can hear.
Okay, we lost you, so you'll please start again.
Yeah, I'm saying as an examiner, we do protect technologies. So for example, if someone brings, as I was mentioning, a baby formulation, you know, it hits the market with a different name. or with a different trademark. So, but I do have examples of a certain lady who protects various hair products, those in cosmetics. And these are basically in creams and conditioners, and they have been protected here in utility. And in the market, they go by the name trademarks. So this, I wish maybe the owner was pushed in advance, could share her journey in coming to Kipi and the challenges she obtained in terms of getting back and forth with the examiners until they got the certificate.
Lewa.
And where they sourced their funds.
Hello, Lewa. Hello?
Yes.
Yeah, I think we can't hear you well. I don't know. You are really giving us some nice story. Yeah.
I can hear you.
Yeah, I'm just saying, we can't hear you
Can you
very
hear
well.
me now?
I don't know whether the rest are hearing us, but
can I
I've
go?
also
Yes.
already seen. Yes, I don't know whether you could close to your computer or something.
No, he just needs to switch off the video.
Or switch off the video.
Okay.
Yeah.
Is that fine?
Now we hear you clearly.
Yes. Good. Thanks.
I think it's the network that is fluctuating or something. So what I was saying is.
Nope, he's disappeared now. Zero, we've lost you again.
We products that we protect because of keeping the trademark. Oh.
Oh dear. Zero, we've lost you. Completely. It's just static. When you ask us if we can hear you, we can hear you. But when you proceed with the rest of the conversation, we lose you.
Okay, but right now you can hear me.
Yes.
Yeah, so what I was saying is that there's a certain lady who protected the various utility models here for cosmetic products and hair conditioners, to name but a few, including alopecia products. But when they go to the market, they go with a trademark. And I was saying, I wish that particular inventor can be approached to explain her journey in terms of seeking protection in Kipi and the difficulties she had and the various corrections she encountered until she obtained the registration, and what kind of funding revenues she explored and the challenges in doing that until she obtained to the market. And while in the market, what kind of challenges did she have in terms of protecting her brand to make sure that people do not actually put products in which they seem to be more or less similar to hers. But generally, Mayan trademark and the Mayan technology by Dayan has actually been one of the stories that have been protected here in Kenya, and it is actually doing well in the market. If you have a computer nearby, you can just Google Mayan alopecia or cosmetic products, and you will get some of those examples. Then we also have Jaramogi Oginga Oginga, which protected a biscuit that is a food product. And they also underwent through the same processes back and forth in coming up with the description and everything. At the end of the day, they managed to protect it. I'm not sure how well it is doing in the market, but that is also one product that is in the market. And whether it is doing well or not, maybe I'm not privy to that particular information.
Okay. We have a question from Abkul Orto asking about what aspects of software can be registered and under what IPR?
The question of our software is always a good question whenever someone asks me, because a software or a computer program basically borders between a copyright and a patent. But it can only qualify for a patent when it has what we call a technical character. But generally speaking, computer programs are written using a source code and they are categorized as literary works. and those are copyrighted by the
We didn't hear that last part. Who copyrights them? Zero, who copyrights?
Board. The Kenya Copyright Board. That is KECOBO. I typed in the chat, the Kenya Copyright Board.
Okay. KECOBO does that.
Yes.
So. All right. Orto, I hope you're still here and responded to. So a few things, I think, from the discussion we've had today, and just wrap it up that one, IPR is about protection, and there are different regimes of protection. And the protection that KIPI offers or KEFIS offers is within the geography of Kenya. Is this correct? It's not Africa and it's not global. So Professor Kimuto, your registration with KEFIS is Kenya only rather than global. Zero, we can't hear you at all now. All right. Professor Kimuto, your KEFIS registration is Kenya only?
If you can hear me?
Zero, hold on a moment. Prof.
Yes, Sonia.
Is your registration only in Kenya? It means if I go to another jurisdiction, I can replicate it?
Yes, we have we have limitations in plant products, mainly. That they are mainly not like patents per se, innovations. If you register in Kenya and you want to go and register in Uganda, it is possible through the East African protocols.
Okay.
So for some time, we've been working on what we call seed harmonization protocols for the East African community.
Okay.
So it will just, if I'll be interested to go and have it in Uganda or East Africa, or any of the countries in East Africa, it is possible for me to go and apply for testing. It's only tested once for one season, just to see the stability and also to check on unique or things that are more diverse, like insect and pests mainly, but East African region have been actually been characterized as like one region.
Okay.
So we've not done that. That is why you could see even in Uganda, Kenya seed will take the hybrid maize across the region, even to Rwanda. So it is possible, but we've not done it.
East Africa community.
Yeah, we have what we call East Africa innovation and harmonization protocols that you just apply and register.
Okay, so thank you. Zero, I see your hand. So you're going to answer two questions as we go to the end
Maybe,
of the
can I add another one? I want to add another question for for Lewa.
Okay.
Yeah, I don't know. We need to ask him. I've not had a time response in terms of time taken for them. The biggest frustration for KIPI has been they stay forever. They never register after application, really. He needs to tell us.
So these are the questions.
Yeah,
so
of course, because why are we not seeing products in the market?
Okay, so thank you. And yes, that's also the question that
Sonia,
by Daniel Midega. Hold on, Lewa, hold on. So two questions for you around jurisdiction. KIPI is Kenya only. Are there other jurisdictions where once you register that these protections apply? And then secondly, this is a question around timing. So to help us understand why it takes so long, is there a way to change the turnaround time and get these products and technologies out there, especially given the positive impacts to society most of them are likely to have. But if you frustrate the innovator, they move on and take a 9-to-5 job. So over to you.
Can I answer those two questions first before I move to the other one?
Those are all the same question. Yes.
Now, if I can start with the question of time, is that every IPR regime has this different timelines as dictated by the law. This is not something that he did mention that it took him around 7 years. Okay. Yes.
I would
you can hear me.
That you change your
You
network.
can't hear me.
If you're on Wi-Fi, can you use your phone network? Your data, because we lose you, and we would really like to hear this response clearly.
I'm actually using my phone network.
Oh, I see. Okay, let's start again.
It's okay now?
Yes, let's start again. Go on.
So I was saying, in terms of the timelines that Prof was mentioning, you see, different IP regimes have different timelines, depending on how they are being dictated by the law and the regulation.
Mm-hmm.
For example, averagely, it will take around 18 months to get a patent finalized, whether it's a rejection or whether it's application has been accepted. And you have to understand that one of the challenges that I always mention is that we have innovators who have challenges in coming up with the right description. And as an examiner, you have to go back and forth with the applicant so that they can be able to understand how to come up with the invention. So if I give the application is filed today, you can hear me, sorry.
Yes, go ahead.
So if the application is made today, the examiner has the stages that they need to conduct, like formalities within 30 days. And then if it complies with the formalities, the examiner has up to a certain period of time, let's say 18 months, but can endeavor to do the application within the shortest period of time. However, it is actually mandated by the Act that publication is done on the 18th month.
Mm-hmm. I'm losing him for a moment, but I think one of the things that I have picked is that it's 18 months if all your paperwork is on point. And it sounds like for many applicants, the paperwork is not always on point. You are on slow mode now.
The reason why, and this is unique to Kenya, that is internet inafanya kweli. You can hear me now?
Yes.
So I'm saying the timelines are usually dictated by the service charter and the law, and also how the back and forth between the examiner and the applicant in terms of correcting those defects. The other one is some of these inventions are not necessarily inventive. They can be new, really, but they cannot be inventive. But an attorney will come back and say, no, this is not inventive with arguments. So the timelines usually here is about what is dictated by the law, unless we change the law. But the 18-month law is basically cutting across generally all over the world if you choose a patent. If you choose another kind of IP, let's say a utility model, the timelines are usually and they're usually between 4 to 6 months if you do not have back and forth in terms of defects. But the timeline is the same if you don't have back and forth defects. You also have to understand that as an institute, we are a government agency, which we are also have to seek approvals to employ. And we have for the longest time, I have understood, a shortage of staff. That some of the staff not cater for all those fields of technologies because we have to undergo all those systems to us to seek approvals to get new examiners.
Mm-hmm.
And as you might have been aware,
examiners are supposed to be specific in those fields. Not any other person can.
Okay.
For me, I'm a biochemist. I can't go and do engineering. So if we are saying two examiners in pharmaceutical and the applications are many, that is also going to, I don't know what's happening with my network, but you just froze.
We keep losing you. We hear bits and pieces. I think the summary of what you're explaining comes down to one, the quality of the application upfront. Is it clear? Are the descriptors precise? Is it inventive in a way that is legally seen to be unique? Is there enough manpower within KIPI and specialization to review that particular application? And sometimes there, well, from the sound of it, there is not. But it looks like it's also possible to put KIPI to task, and I guess for KEFIS as well, given the service charter timelines. So allow me to use that as the summary to what you were saying, and also to thank everyone for joining this. Abkul, we've heard that they may not have the people to do so, but some things I'd like to think we have learned and unlearned. One, IPR is about the regime and the rights, and so you're protecting your products under different frameworks. Your technology rather and your invention, whether it's a patent, utility model, or if you go to KEFIS around plant breeder rights, the importance of your trademark and the pathway to follow is research, protect, and then commercialize. There will be challenges to IP registration when it comes to funding. So every researcher needs to think about how they're going to raise that money once they identify the right regime. And commercializing your technology does not necessarily put you in the market, because those are two different processes and products. One is the technology, the other is how you look in the market. Are you a seed? Are you a washing soap? What are you that makes you unique, and therefore you go to market? And then thinking about your model for commercialization, which is probably a topic for another webinar. So thank you all very much for joining us. Professor Kimurto, it's very early in the morning where you are. We really appreciate your insights. Zero Lewa, as always.
Okay, hello everyone. I think we have lost Sonia at some point. I think, so what Sonia was doing is that we were just appreciating Zero and Professor Kimuto for coming in. This has been quite a discussion. I mean, there is a lot we need to learn in relation to what we need to do in relation to IPR and patenting itself. And I think it was really a good discussion, and we can see that feedback as well on the chats. So just as agreed, it was a 1 hour webinar, but we would love to hear from you about what other topics we can bring into this webinar so that we can have more and more of these interactions so we can learn from each other. But at this point is just to close it off. Again, thank you, Kimuto, thank you, Lewa, and thank you to everyone else who has joined us.
Thank you so much. Much appreciated.
Much appreciated.
And I want to thank Lewa for the good insights on the patenting process and why they tackle it. Thank you so much.
Karibu, Prof, and sorry for the network challenges.
Asante, thank you so much.
Yeah, thanks everyone. You have a lovely afternoon and great rest of the day.